So that means everyone should be able to hear me, correct?
Yes.
Okay, cool. Hey, welcome to the second workshop for the criminal justice and behavioral health workshops that we've been putting together. My name is Mark Fall, Workforce Development Administrator for Care First Health Plan, and with the assistance of Sydney and Michael, we are here doing the second workshop. Here it's entitled Criminal Justice 101. We have some professionals here who are going to walk us through this and give us a great overview of this. We have Keaton Williams, who's the Deputy County Attorney, who will be presenting. And then just also have to say that Joe Carver is here as well, legal defense from the Legal Defense Office, if I'm correct. And we'll be also answering questions if needed and making sure that Keaton, stays within his lane here. So Keaton, thanks for coming. Hopefully everybody can hear. Please be sure to type any questions in chat, and we'll do a question and answer afterwards. And we'll be happy to answer questions throughout the presentation. So thanks, Keaton.
Thank you. So for our second workshop today, I'm presenting the basic overview of the criminal justice system in Coconino County. As you heard, my name is Keaton Williams. I'm the Deputy County Attorney. Been with the Coconino County Attorney's Office for about 4 years now. And I am our Pathways Diversion Coordinator, as well as our Mental Health Court, Recovery Court, and Page Drug Court Prosecutor. Mr. Joe Carver, who's the Deputy Director at the Legal Defender's Office, is also here and will give a unique perspective on some questions and answers today as well. So the purpose of this talk is to present the criminal justice system here in Coconino County specifically to those who work in the behavioral health field. So if you're joining us today from the criminal justice side, we're glad to have you, but some of this may seem a little elementary to you. We're just trying to give a good overview so that folks working here at the Guidance Center, where we're here in person, or other places in town, when they have that contact with the criminal justice system, they'll have a little better idea of what's going on when they're hearing it secondhand, thirdhand. So there's 3 main topics I'm going to touch on today. And those are the courts that we have here in Coconino County. Not only what are those courts, what do they oversee, where are they, those type of things. Second is the offenses. That is going to be primarily split between misdemeanors and felonies. That is the main division in the criminal justice system. And the main difference to start off is prison. You can go to prison for a felony, you cannot go to prison for a misdemeanor. But we'll get a little more in depth on that. And last, I'll walk through the process of a case. From a person getting arrested to sentencing to what we call post-sentencing. Things like probation, appeals, and that. So to start us off, we're going to talk about the courts. There are 3 types of court in Coconino County in the criminal justice system. There's the municipal court, the justice court, and the superior court. Starting off with municipal courts. So we have 4 of them here in Coconino County. 1 here in Flagstaff, which is the picture you see on the screen. There's 1 in Fredonia, there's 1 in Williams, and there's 1 in Page. These courts, in the criminal justice perspective, are overseeing misdemeanors and petty offenses from local police. So, in the case of Flagstaff here, this courthouse is dealing with misdemeanors that are from Flagstaff Police Department arrests. A petty offense, which we'll get into a little further when I talk about offenses, is another type of misdemeanor. Same thing, Williams is Williams PD, Page PD. Justice courts are also a court of limited jurisdiction, similar to a municipal court, where they're primarily dealing with misdemeanors. The difference here is that they're dealing with misdemeanors from outside city limits and from the other law enforcement agencies. So again, we have 4 in Coconino County, 1 in Flagstaff, 1 in Fredonia, which for those of you who don't know, this is the Fredonia Justice Court. There's a Williams Justice Court, which is actually the same building as the Williams Municipal Court, and same with Page. So to give the Flagstaff example here, and a UPD, the sheriff's office makes an arrest, it's a misdemeanor. It's going to go to the Flagstaff Justice Court instead of the Flagstaff Municipal Court. For those in the behavioral health field, who are talking with people who are a defendant in a case, a suspect, or have received something like a summons, the best way is whatever piece of paperwork they have is going to say right at the top what court that is. And that will at least help you get them in the right place. If somebody, is saying, hey, I have court, here's where I need to be. The Flagstaff Justice Court is in that big old courthouse right on San Francisco. That's also the Coconino County Superior Court. Flagstaff Municipal Court is the newer one, a couple blocks over off of Cherry and Beaver. In my experience, I'm sure Joe's probably seen the same through his years. The number of people who I've seen show up into court and sit through parts of court in the Flagstaff Justice Court when they're meant to be at the Flagstaff Municipal Court is a lot higher than you think. So that helps get people in the right place, helps them avoid warrants. It's always a great start to be in the right place at the right time. A unique aspect of the Justice Court is they will handle preliminary felony proceedings in some cases. I'm going to talk a little bit later about how felony cases are filed, and I'll get into that more. But you will see a felony case that's being handled in one of these justice courts to an extent. And lastly, we have the Coconino County Superior Court. It is the only superior court in the county. It has jurisdiction over felonies. It has final jurisdiction over felonies, which means that if you are going to trial on a felony, it will be in the Superior Court. This picture here is Division 2. That's the old part, or sorry, Division 1. That's the old part of the courthouse. Felonies filed through an indictment will go straight to Superior Court. And again, I will get into that a little bit later. So our next step is the offenses. So we've talked about the 3 different courts for a total of 9 different courts in Coconino County with the different cities. One of the big issues you'll see interacting with people is figuring out what type of offense. And that will also help you get an idea of where they are in the process, where they need to be. So misdemeanors, we have 4 different types of misdemeanors. Class 1 is the most serious. The penalty for a class 1 misdemeanor is up to 6 months jail, a $2,500 fine, 3 years of probation, or 5 years of probation if it's a DUI. Common class 1 misdemeanors, to give people an example, are DUIs, reckless driving, assaults such as punching someone where there's contact. Class 2 misdemeanors are 4 months jail, $750 fine, 2 years probation. And class 3, we have 30 days jail, $500 fine, 1 year of probation. Class 3, we're looking at things such as the fire bans, things such as criminal speeding, going 20 miles an hour over the speed limit. And then lastly, I can't think of any class 2 misdemeanors off the top of my head, to be honest, Joe.
Criminal trespassing.
Criminal trespass in a business or in a residential yard.
Right, yeah.
So that's a good example of a class 2. They're not as common.
No,
Last-
it's a weird one where they don't step down in the 6 agreement.
Yeah.
It skips the last one for whatever reason.
So lastly, we'll go to petty offense. This is defined as a misdemeanor that you can't go to jail on. The most common petty offense I can think of, and again, no jail, no probation, just a fine. That's all that can be done. Not having an adequate number of life jackets is a very common petty offense. Where you receive a fine and that's it. It is still considered a criminal offense, but it's no possible jail. So things about misdemeanors you can see at the top. Jail, fine, probations are the penalties. And then generally, if a person wants to take these to trial, it's a bench trial, which means they're not in front of a judge, they're not in front of a jury, they are just in front of a judge. There are exceptions to this, with DUI being the most common. Lastly, the limited jurisdiction courts, so the municipal courts and the justice courts, have complete jurisdiction over misdemeanors. So a person who is charged with a misdemeanor will be in municipal court or justice court through the entire process, including trial. Felonies we have 6 classes. Again, the main difference is that prison is a possible sentence on a felony. In addition to jail, probation, all felonies have the same maximum fine of $150,000. With felonies, the final jurisdiction is with the superior court. So whenever I talk a little bit later about the process, even though some felonies may start in a justice court, felony trials, which are always jury trials, either 8 or 12 person juries, those will always be in a superior court. And again, I'll briefly go through. Class 1 felony is considered a capital offense. These are the 2 offenses that are punishable by the death penalty or life imprisonment. Class 2 is a 3 to 12.5 year prison sentence, up to 7 years of probation. Class 3, and I'll step back. Class 2, fraudulent schemes is a well-known class 2. Some forms of child abuse as well, and then things like what we'd call manslaughter generally. But that's where you're looking at class 2. A class 3 is 2 to 8 3/4 years prison, 5 years probation. Class 3 involves some assaults, some burglaries. Stepping down, class 4, again 1 to 3 3/4, 4 years probation. Very common class 4s are aggravated shoplifting, something you might see, or most types of an aggravated DUI. Class 5, we're down to possible half a year to 2.5 years, 3 years probation. Class 5 is a aggravated assault on a law enforcement officer. Is an example of a class 5. And then class 6, the minimum prison sentence on that is 4 months to 2 years, 3 years probation. A common class 6 is paraphernalia. So one thing I wanted to touch on before I talk about the maybe undesignated with the class 6 is that with each of these numbers can change. Arizona has certain designations, such as a dangerous felony, as well as repetitive felonies that can change these numbers. So just because you've seen these numbers doesn't mean that it will always apply. If someone is a repetitive offender, these numbers move up significantly. Good. All right. Moving back to the class 6, this is very unique. A class 6 may be treated as a felony or a misdemeanor. And for a first-time felony offender, that can even be done at trial. So it is possible for a person to be charged with a class 6 felony, go to trial, be convicted, and then end up with a misdemeanor at sentencing. So class 6s are very unique because they can be either or, and they're the only ones that can. All right, moving on to criminal procedure or the process. I will now walk us all through just generally what happens from an arrest through sentencing. There are a lot of nuances to this, but I'm hoping to just give a good overview so that if anyone in the behavioral health field has someone come in and talk to them, again, you can have an idea of where they are in the process, what might happen next. So with an arrest and booking, I've kind of split this up into misdemeanor and felony. So misdemeanors are generally filed through an officer filed complaint or a traffic ticket. This will often be a fill in the blank kind of worksheet that an officer has. They will very frequently take whatever they have from their shifts for the week, walk into the courthouse, turn those all in. Another thing with a misdemeanor is you often see cite and release. And what that is the officer has decided not to arrest the person. They're writing them the citation, they'll even give them a copy, but they're going to let them go. If they're arrested, they must see a magistrate within 24 hours. And if they're under arrest, a complaint must be filed within 48 hours. So in this case, that's that officer filed complaint. I'm going to walk through the felony and then talk a little bit more about that complaint filed within 48 hours. A felony, almost always the person is arrested. There are some situations, generally you'll see when there are health concerns, where an officer can long form a felony complaint. And then they may be immediately filed and issued summons. And this is done, at the time of the arrest. And then one of the unique things that I'll get into more in the next slide about filing a complaint is that with felonies, my office, the county attorney's office, is involved and reviews matters and files complaints. The same requirements are in place for a person in custody, and that is that they must see a magistrate within 24 hours, and a complaint must be filed within 48 hours. As I said earlier, I work at the Pathways office that's within the jail. I have a lot of communication with people in health and human services on different programs, and this is one of the things I see most often is what does no complaint file mean? So what a no complaint file means is that a person was arrested and a complaint was not filed within 48 hours. So what happens then is the case is dismissed, but it is dismissed without prejudice. So what we often see is an officer will have cause for an arrest, they'll arrest a person, they'll be booked into jail, they will be seen within 24 hours by a magistrate, even on the weekends. They'll do their initial appearance, they'll possibly have a bond set, and then there's no complaint filed. And then the person's released. This does not mean the case is over. It does not mean it can never come back. It just means at this time, whether there was additional evidence gathering, whether for a number of reasons, that complaint just wasn't filed within 48 hours. And when we talk about filing the complaint, you can see here that the statute of limitations is at least 7 years for a felony. And so with a misdemeanor, it's filed by the arresting officer. It's generally done almost immediately. And there's a statute of limitations of 1 year if it's not done immediately. Felony, it's filed by the county attorney's office. Sometimes that's done immediately. Often it's done within a few months. And that is, there are only so many judges in the court. There are only so many attorneys in my office. And sometimes priority decisions have to be made. If someone's committing a violent offense, if there's someone in danger, you are more likely to see that done immediately so that they are held in jail. If there is something like a paraphernalia possession, that type of thing, it will often be filed later once our office has reviewed it. What that looks like is the police officer puts together narratives, puts together evidence, and provides that to their supervisor, to a detective. They review that, they put together a charging request packet, send that to my office. We have an attorney review that, decide what charges will be filed, and then file those. So that's when you're seeing the no complaint filed. There is a process to that. And really what that person does, if you're interacting with that person, they say, I got arrested, they told me no complaint filed. Their number one priority should be to make sure their contact information is updated with the court. And the judge will tell them that, but not everybody who's getting arrested in the night and being drugged in front of the judge the next morning is going to necessarily remember everything. So that's really, my words of wisdom with that is that when that case is filed, the court will try to contact them. If they cannot contact them, they will almost always issue a warrant. And so if the person keeps their information updated, they can stay out of custody, appear at a summons, much more pleasant process, less disruptive to their life. And that can be done by keeping your information updated with the court. So this touches on where felonies start, as well as with the process. Felonies can begin with either a complaint or an indictment. A complaint is generated by the county attorney's office. It's signed by either an officer or an attorney, and then it is filed in justice court. With this complaint, it begins the case, but there's no finding of probable cause yet. So a felony that is filed in justice court has 10 days, if the person is in custody, to do what's called a preliminary hearing or a probable cause finding, or 20 days out of custody. Oftentimes these deadlines are waived, especially when a person is out of custody, so that the attorneys can engage in plea negotiation, defense counsel can provide mitigation, those type of things that time is also often waived. Then, very often what can happen is a plea agreement is agreed upon, and the person will then waive up to superior court and say, I'm happy with my plea. I don't need a contested probable cause finding. I would just like to go to superior court and enter in my plea. And whether that's waived or it occurs, the probable cause finding, all proceedings from then on are in superior court. An indictment is something that's generated by a grand jury. So that is, a jury of your peers but in a different sense. So instead of sitting in on a trial and making a determination of guilty or not guilty beyond a reasonable doubt, they instead are determining whether there are probable causes. The grand jury sits weekly. They hear cases from officers, and then they will generate or not generate an indictment for those charges. At the end of each day, a judge from the Superior Court comes in and will enter those straight into the calendar, send out summons, and start the scheduling. Those go straight into Superior Court. And the reason for this difference is that a probable cause finding is required on every felony case. But in the case of an indictment, that's done by the grand jury. That's the probable cause finding. Whereas in the case of a complaint, it's done at a contested hearing in front of a justice of the peace or magistrate in the justice court. So stepping back, two things that you'll often hear are the initial appearance and the arraignment. So the main way to keep these straight is that an initial appearance is triggered by arrest. An arraignment is triggered by a complaint or an indictment. They are often combined. But here are the differences. So an initial appearance, that's 24 hours within an arrest. That's when you're seeing the magistrate in the justice court the next day. They're confirming the arrested person, the defendant's name. Sorry, I'm using some abbreviations here to keep my slides a little compact. D is defendant. Informing them of the charges against them. And they are also making a probable cause finding, but only for purposes of release. So at this time, the magistrates provided a probable cause statement from the officer saying, here is what led to this arrest. And they're just reading that, matching it up with the offenses that are listed for the arrest, and making a very preliminary determination. Okay, there is enough here to set a bond. And so at that time, they will appoint counsel and then set bond or bail. One of the things that is often seen is, or overheard, is someone was released OR. That is on recognizance. And what that means is they're released on a promise to come back. They're not doing any bond, anything like that. An arraignment is triggered by the complaint or indictment. It must be held within 10 days if the person is in custody, so if they're in the jail. Held within 30 days if they're out of jail. Again, they're being advised of the charges, although these are now the charges in the complaint or indictment as opposed to the charges from the arrest statement, from the booking. Assure that they have counsel. Enter plea, and what I mean by that is not a plea agreement, but this is generally when the person says not guilty, I plead not guilty. The most common times that a person goes into an arraignment and pleads guilty are with some of those petty offenses, class 3 misdemeanors. Yes, I wasn't wearing my life jacket. You see these much less frequently with more serious cases, felonies. At this time, they'll also set a later court date. That is often called a status conference, a pretrial conference, are the two most common terms. What happens at a status conference is before the first one, at the first one, the defense counsel is provided with disclosure. So these are police reports, evidence, body cam footage, as well as often an initial plea offer that the state is making. Most times in felonies, these are provided ahead of time. Misdemeanors, they're more often provided at that time. One of the reasons for that is in Arizona, the right to counsel only applies if someone is facing jail time. So for many cases in misdemeanors, if the state is not seeking jail, then counsel will not be provided. So people will represent themselves in the misdemeanors. It's much easier for my office to send emails to the attorneys than it is to track down each person charged with a misdemeanor and try to get things to them. So, and I'm sure it's the same for all the city attorney's offices as well. Much easier for misdemeanors to just hand the person the packet when they show up at their first court date. Often the next step is that there's mitigation, counter offer provided. My office, the prosecutor, provides a plea agreement. Here's our evidence. Defense comes back, hey, since the time of this DUI, this person has gone to treatment. This person has done these things to better their life. Would you consider a more lenient plea offer? This may go back and forth many times. I'm looking at Mr. Carver, he knows. Often it's a handful of times. So these status conferences, pretrial conferences, are generally set out every 2 to 4 weeks until a decision is made. And what that means is my office shows up, here's the plea, here's the disclosure. Defense counsel says we'd like a couple weeks to gather mitigation, make a counter offer. That happens. Next time my office says we'd like a couple more weeks to consider the counter offer. So that's your usual 2 to 3 status conference process. In some cases, the defendant's presence may be waived. So if you have a person telling you they don't need to show up to their court date, make sure to check that with their attorney. It is something that can happen, but it's not always super common. This is also the point where consideration and screening for treatment courts occurs. I'll talk a little bit more about those courts later, but this is the time where defense counsel says, my client has a serious substance abuse issue. I think they would be appropriate for recovery court. And this is where that process occurs during these status conferences. In misdemeanors, sometimes the change of plea and sentencing also happen at that. So it is not unheard of to have a person walk into their first status conference, pretrial conference at a misdemeanor, receive their plea offer, decide they like it, sign it right there, get up in front of a judge and be sentenced. In felonies, there is more of a process and those are set out. The court doesn't have time set aside for doing those all at once. So case ends in one of 2 ways, conviction or dismissal. Conviction may be through an admission, such as a plea agreement, maybe through a conviction at trial. And one of the things here for both a jury conviction or a plea agreement, if the person is not probation eligible, either through a plea or they're a repetitive offender, it's a dangerous offense, they will be taken into custody at the time, at the end of the trial or when they enter the plea agreement. And unless the parties agree otherwise, but that is the general rule under the law. Dismissal may also be done through a plea agreement. Some case, an entire case or some charges may be dismissed. It may be done by the state. New evidence is provided, some type of mitigation. Sometimes this is through a more formalized agreement known as a diversion or deferral agreement that says, most common, you'll see these with first-time drug offenses, first-time misdemeanors. Stay out of trouble for a few months, go engage with some treatment, and the case will be dismissed. It may be done through an acquittal at trial, that is, the jury decides or finds that there's not evidence beyond a reasonable doubt, and the person is found not guilty. And it may be done through a judge. Defense counsel may file a motion to suppress some evidence, things like that, without getting too in depth. Also, we talked about the preliminary probable cause finding. If a case goes in front of a magistrate, it's filed by a complaint. The magistrate decides there is no probable cause, then that case is dismissed. Lastly, I'll talk about sentencing and post-conviction. Sentencing is a lot of it is at the judge's discretion. A lot of it may be restricted by plea agreement. When I went through the misdemeanors and felonies earlier, you saw up to 3 years probation, X years of prison, amount of fine. And to add this right now, some of that is also set by statute. There's mandatory jail time for DUIs. There are mandatory fines for methamphetamine possession or DUIs. So some is the judge's discretion, some is decided on the plea, and some is actually statutory. So also it's sentencing. This is when any victim, any members of the public, family members, this is geared towards people in behavioral health. So if you have a client that you've been working with, this is the time where you legally have the right to make a statement. A lot of times people will try to make these statements at the change of plea, but all that is accepting the plea. It's the sentencing. It's when the judge takes those type of things into consideration. And often probation, if it's going to be a probation plea, will be there in the courtroom, get the person started, set up their intake, those type of things. Lastly, there are post-conviction. So these are things such as appeals, your probation meetings, probation revocation, and orders to show cause. Appeals are much more common after a conviction at trial. When a person signs a plea agreement, they are waiving most of their rights to appeal, except for some extreme cases. Meetings with probation may be part of a person's probation term. Again, revocation is then new court proceedings start if someone's being revoked from probation, where probation will either possibly ask them to do a short jail term, be sent to prison, being reinstated on probation. These are violations that are then go back into the courts. Lastly, a common hearing that you may see is an order to show cause. That means someone has not complied with something in their conviction. They have not paid a fine. They have not done a substance abuse screening. They have not provided that they've done a class. It's those type of things. There will be an order to show cause here. So, very last thing, I'll talk a little bit about alternative prosecution and treatment courts, since that is what I do at our office. So a couple examples up here. Sorry, Recovery Court and Page Drug Court don't have logos, so they got left off. But the pathways at the jail provide reentry services, as well as the pre-charging diversion program. Mental health court is part of the Coconino County Superior Court. These are the programs that I am aware of. I do not work in any of the municipal courts, so this is what I was able to find online, is that the Flagstaff Municipal Court does have a mental health court, which is some type of deferral program. In the justice courts, the Page Drug Court is out of the Page Justice Court. It works very similarly to the Coconino County Recovery Court. It is for people facing felonies. And it is a approximately year-long intensive probation program focused on substance abuse treatment. The Pathways Pre-Charging Diversion Program is a program for people who have been arrested, but no complaint or indictment has been filed yet. So, and what that is my office enters into an agreement that says if the person stays out of trouble, engages in treatment, then our office will not file a complaint. So a person is able to avoid having any felony charges filed against them under that program. Lastly, Superior Court, we have the Coconino County Mental Health Court. That is again for people facing felonies. This is for people who are SMI designated, and it is a approximately 1 year long intensive probation program. Lastly is the Coconino County Recovery Court. Again, these are for people facing felonies. It is for people with substance abuse problems, and it is approximately 1.5 to 2 year long intensive probation program. So, my contact information. Myself and Mr. Carter are here now if anyone has questions for us.
So I do have a couple questions that came into the chat earlier. So the first one, in regards to the classes of felonies and misdemeanors, and the question is, are the class designations, so 1, 2, 3, 4, etc., the same in every county, or is that specific to Coconino or Arizona or nationally?
That is specific to Arizona. So all counties in Arizona will have those same classes of misdemeanors and felonies. That's put together by the state legislature.
And then we had another question from our law librarian. She said often she gets people coming to the law library that say, how do I take someone to court for a crime? She is telling them you would report the crime to law enforcement, they'll investigate. Law enforcement or the county attorney will decide whether to take that person to court. And she lets them know an individual does not file criminal cases in court. Is that correct? Is that correct advice?
That seems sometimes largely correct to me. I'm obviously on the other end of that. I'm never, eager to advise anyone to seek prosecution. But there are some odd quirks in Arizona law. If you look, there's buried in there the ability for a citizen to bring a criminal complaint to the justice court. It's never utilized, but it's there. But yeah, that's largely accurate advice.
I would say, yeah, the same that, talk to the police. The idea of pressing charges isn't, as you'll see on TV, isn't as applicable in the real world. The police will take that report and make a decision.
We have one more question in the online chat. What does suppression mean when evidence is suppressed?
So
Yeah, that seems a little more
total suppression on the defense side. Suppression just means whether evidence that the police collected is going to be admissible at trial. And it comes about usually when there's an allegation of a constitutional violation. So most commonly, this will occur in drug cases where a law enforcement officer, usually DPS, will do a traffic stop, and one thing leads to another, and they find the person has contraband in the vehicle, sometimes in the home, sometimes on the person. And the Fourth Amendment restricts law enforcement's authority just to seize and search an individual without any reason or cause. And so if the defense sees indications that the search or the seizure was unconstitutional, that is, was without reasonable cause or probable cause, without a warrant, the defense will file a motion to suppress, meaning court order prohibiting the state from using that evidence in trial.
So, yeah, piggybacking off Joe's example, I was talking about that within the context of the dismissal. So if defense files a motion to suppress, all of the contraband, all of the drugs are suppressed, so the state is not allowed to introduce any evidence of the drugs at trial. That case is not going to go anywhere, and it will very likely end up just being dismissed by the state. Or there are some situations where the court can actually just dismiss the case. This is one of those that I started to type, and then it could be an entire semester law course on its own. So. It is, yeah, it is.
I have a question. So you talked about indictments and you talked about complaints. What about informations?
So information is what happens when a case that has been filed by complaint is then moved to superior court. So generally that will reflect the complaint. Occasionally, what can happen is there's a probable cause hearing. The magistrate says I find probable cause for counts 1 and 2 and not 3. So count number 3 does not appear on the information because it does not get to go to the superior court. So yeah, information is just preparing, letting the superior court know this is what this case is coming up, because superior court will then conduct an arraignment at that level as well.
Thank you.
I have a question. Can you guys describe and talk about what a settlement conference is and how each party prepares for that? And the last question is about settlement conferences. How can programs that are supporting defendants, how can we support them for that settlement conference? Like, are character letters helpful for that?
Well, you want to start on that?
Yeah, the settlement conference is kind of like a negotiation of last resort. Typically, settlement conference will, well, just to back up, the settlement conference is provided for by the rules of criminal procedure. So there's a specific rule that allows these things to happen. The trial judge, so the judge that has the case in front of on their docket, hearing after hearing, is not supposed to do the settlement conference where we get a neutral judge or an uninterested judge, somebody who just can hear the facts of the case and not face charges of bias later on. But typically we get to that point because, you know, Keaton and I have been fighting for months and months. He's unreasonable and won't agree to a compelling offer. And so we asked the settlement judge to get involved to mediate, basically. So on the civil side, in family law, there's a lot of mediation. This is kind of the criminal version of mediation. And the settlement judge tries to find common ground, see if there's any place where we can meet, have a meeting of the minds to resolve the case short of trial. And just to be fair to Keaton, and I'm using this as a joke, but they oftentimes the defense will use the settlement conference as well to get somebody who's got a good plea offer to understand that that's a good plea offer. And the defense, especially if you're an indigent defense attorney such as myself, it takes time and sometimes you never achieve trust with your client, and so it's helpful to have an authority figure talking to them about how, hey, your attorney's right, this is actually pretty good. The way they work, I think this was part of your question, but the way they work is, at least in Coconino County, they work differently in other jurisdictions, is that we all sit down in a room. It's pretty informal. The judge is recording it, but he always explains that's for his own protection. And we make sure that we are all working on the same information, that we both agree on what the charges are, we both agree on what that could mean if there's a conviction at a trial, and we agree at what stage the negotiations are at. Then the prosecution will leave, and the judge will talk to the client and the attorney for as long as they need to, really, to get a sense of what it is we want to get out of the negotiations. And then the judge goes and tells the prosecutor gives their point of view on the case, and the judge will go back and forth as many times as it needs or until he runs out of time. Until it's clear that we're not going to reach an agreement, or we do have an agreement. In terms of how can people in behavioral health and support defendants, how can you help in that settlement? I mean, that's your ability to help is largely on the defense attorney reaching out and requesting information. But if you know that a client is headed to the settlement conference and you have information that this could hinge, the decision here hinges on whether it's a pivot point, right? Like he's either gonna go to DOC or he's gonna get probation and treatment. Then, yeah, things like character references are helpful. I don't know what would be most convincing to a prosecutor, but I think when I'm thinking about it, what would be convincing to me isn't just a statement that they've been participating, but like the data, like they've been here for these days. They missed this appointment, but it was because of X, Y, or Z. They've been taking their meds, they show up for their refills, you know, like nitty-gritty sort of stuff. The summary is easy to read and meaningful, but I think sometimes the like overselling it sometimes is the most convincing way to do it. But
yeah, just to build off of that, yeah, those type of character letters, the person's in this program. I would say if you have the ability, you know who their defense counsel is, you're aware of the proceedings. Those are useful as early as possible. They can be useful in not getting to the point of a settlement conference, in initial plea agreements. But yeah, they're something that's considered in settlement conferences. Like I said, it's kind of like the last resort plea negotiations. Like we're going to sit down in a room and we're going to either walk out with a signed plea agreement or a trial date. So, and the same thing, the nitty gritty, the understanding they're participating in these programs. I've seen a lot of they're a good person letters. I have to say, to be frank, that those aren't as convincing. Most people can find someone to write them one of those.
and most people that end up in the system are good people.
And that's not, yeah.
It's that doesn't necessarily distinguish them in the eyes of the prosecution, because there's a crime that occurred in the community that needs to be resolved. So there's that perspective too.
Yeah, absolutely. So yeah, giving that explanation to try to help us understand what steps does this person take to address behavioral health issues, substance abuse issues, if those are what's related.
I think in terms of the settlement conference, that what could be helpful going back, I haven't done this before. I think I've heard of other attorneys who have tried it, but if I'll be the first to admit that you all know more about the criminal justice system than I know about the behavioral health system. So, but I can see that there would be an advantage at a settlement conference or negotiations at any point where the person has their behavioral health or mental health advocate come with them and is there to be I always find face-to-face stuff more appealing, more convincing, which is why the pandemic was so difficult in the courts, because it's just that much more difficult to be persuasive. But oftentimes a specialist such as yourselves are able to, I don't want to sound crude, but are able to translate, right? Are able to talk to a judge or the prosecutor about when Joe's client is speaking this way, which to the untrained observer is crass and rude or arrogant, this is a manifestation of their mental illness, or this is what they're trying to get across, or not be disrespectful. So, you know, I can see as you moving forward, like how we can advance those conversations in the criminal justice system and have a more nuanced understanding of those. It could be very helpful at the end of the day at one of these settlement conferences. Okay.
Thank you.
Was there any other part to that?
No.
I have a really bad habit of just like answering the question that I think I want to answer.
We just should want to support people and just knowing like, how can we best support this person? And, you know, we have the ability to see like what they're doing in the community and be able to present that to the court, so that is helpful.
Can you guys talk just a little bit about pretrial release and pre-sentence reports? And just briefly about those?
Yeah. So pretrial release, currently is, either out on your own recognizance or some type of bond. And so that's essentially there for the court's assurances that someone's going to show. That's something that's decided, at an initial appearance. It can be modified. The court's making that determination based off of things like connections to the community, prior criminal history, ability to pay. And so that's what pretrial releases is. What is that person's conditions that they're not going to sit in jail throughout the entire proceedings? And then a pre-sentence report is done in felony cases. That's why, one of the reasons why we only see that status conference, change of plea, sentencing all stacked into one afternoon with misdemeanors. So once a person enters a plea agreement, they are then ordered to go and call probation. They will sit down with a probation officer prior to their sentencing. And they will go through a series of questions about criminal history, how they feel about the process, trauma history, substance abuse. And probation will make a recommendation. So a plea agreement may say, this is probation eligible, it's a, you know, class 5 felony, and then everything else is left to the court. So the judge is relying on that in addition to, you know, my arguments and Joe's arguments. They have a wide range of this person's on 6 months of probation, this person's going to prison for 2 years. And the pre-sentence report is something put together by probation to help the courts understand that person's needs, safety concerns, all of those type of things. You have anything to add to that?
The only thing that comes to mind is that and you may have been aware just through consuming media that pretrial release or bail is the shorthand for pretrial release conditions. It's slowed down, but there's been reform efforts throughout the country to get away from money bail, and those efforts came to Arizona, and there was a big rewrite of Rule 7, which is the pretrial release rule, basically like when courts can and under what conditions release an defendant. I think that's relevant for the behavioral health community because that is in effect resulting in the courts putting a lot of the onus of release of these people on the behavioral health system, because a lot of the conditions of release will be related to if you need to take medications, you need to be compliant with those. If you are receiving counseling or treatment, if you're at the guidance center, you have to be compliant with that. And so it outsources in a lot of ways the guarantee that these people are going to appear for court in the future to other organizations that aren't directly connected to the court system. I think that that's obviously a move in the right direction, because it's silly in my mind to have somebody sit in jail on $1,000 bond and then just gonna sit there because they can't pay it. But you must also recognize that we're moving the responsibility over. We're creating more hurdles. Even as we're reforming the release system at large, so just have to be aware of when that happens, and be aware that you just still have to pay attention. You still have to be alert for complications, right? I guess that's what I was trying to try. You got to be alert for unintended consequence, which really isn't to the question, but I thought that the bail reform has resulted in a lot of, or I would say, pressure on us for sources outside of it.
Are you guys lawyers or something? Can you add to that and talk about pretrial services supervision and what the purpose of that is?
That's pretrial. To me, the pretrial is for folks that would have otherwise not been released on bail or released on their own recognizance, right? So the expansion of pretrial services, or at least the courts think that pretrial services has been expanded, whether probation has the resources or not, no one seems to really consider. But pretrial services is an attempt to take people who a judge would have otherwise held out a $5,000 bond and give them an opportunity to show up, but they're being held accountable. At least the judge feels like somebody's watching them. So it's a good program. I think I started practicing in Chicago, and there was no such thing. And so people would just sit in Cook County for months and months on misdemeanors, and it was absurd. And then I was in Mojave County, and there wasn't pretrial. There might be now, but there wasn't when I was there. So when we got here and there is pretrial, I thought, oh, this is great, but this is a good resource. But again, I guess as an antagonist in the system is you always have to be alert for when is this being abused, and when is it not actually helping. So I feel that sometimes the courts are putting people on pretrial when they should just be released a lot. They should just be allowed to come to court on their own. And because probation has a limited amount of resources, so they can't be surveilling everyone. So let's reserve that for the appropriate case. And that's just my 2 cents, I guess.
So essentially, they're being overseen by probation during that time.
Yeah, right. I like to explain, it's probation before you're convicted. And I will say that I've had some positive experience of that impacted cases where a person's been out who otherwise wouldn't be, and has been very compliant and proven themselves as someone who would likely be successful on probation, when maybe going in and reading the charges wasn't my first impression.
So if somebody like a case manager is working with a client, whether it's here at the guidance center or Southwest, wherever, and their client tells them, I think I have a warrant, what do I do? What's the best way that you would suggest that they, like, what direction could they maybe point their client in, who to contact, where to go, if they think they have a warrant and they might sound like they're in a place where they want to take care of it?
I would say the first immediate thing that the person could do is look up public access. And that is, for those not in the criminal justice system, you can search Arizona Public Access, and you can search by name and look at criminal cases. And they should tell you whether that case is in warrant status. And then help the person. Pretty much every court has walk-in hours. And what that is a person who has a warrant can go and walk in and have their arraignment. Show up, get the warrant. Although I don't deal with that as much firsthand, so I'll let Joe take over from there.
It depends on, again, where they are in this process, because if it's pre-arraignment, so let's say they fail to appear for their first court hearing, but a warrant issued, they will almost certainly not have an attorney at that point. So at that stage, they're on their own to figure it out, although my office is usually more than willing to take a call, and we're just like, hey, we don't represent you, the court has to appoint us, but we can see from our information if there is a warrant. Justice court does walk-in hours at such and such a time. After they've been appointed an attorney, the best person for them to contact is their attorney, because their attorney can file motions, contact the prosecutor, and basically assure a certain outcome when they do walk in. The risk that you face, I see, in advising a client who has a warrant, is telling them what's going to happen if they do walk in, because while the vast majority of the time, in my experience anyway, the judge will reward a person for coming in and cleaning up the warrant on their own and let them go back out. The judge is under no obligation to do that. There's no rule that requires the court to release that person back to the community if they walked in on their warrant. So you gotta be real careful about telling them, oh yeah, just go in and get your warrant quashed and just leave it at that. They are thinking that there's no way I could be taken into custody because the court can.
Thank you.
I have a question about class 6 felonies. I know you mentioned that they can be designated, undesignated. What or who makes that decision? Is it the actual offense, or is it the?
So yeah, if an offense is a class 6 felony, and that's under statute, then as long as the person is a first-time offender, it can be either a felony or a misdemeanor, and that decision can be made immediately upon sentencing. After that, it's generally happens throughout plea negotiations, where something's pled down to a class 6. A common thing is that in pleas it'll be, or even judges sentencing, someone won't be able to have their offense designated as a misdemeanor until they complete probation. So you'll see those type of things in plea agreements and that. But as far as the law is concerned, a first-time offender in class 6, it can be either a felony or a misdemeanor, and that would be the judge's decision to sentence.
The just to insert myself again to the question. The rules recently, or those laws recently changed on designated offenses. For years, if you were convicted of a class 6 felony and it was undesignated through a plea, or the judge made it undesignated, that offense, this is almost always results in you being placed on probation. Right? While you're on probation, that offense was treated like a felony for all purposes, right? So it was like if you were making an application to a job and says, do you have a felony conviction? You would have to say, oh, it's undesignated, but you have to write, yes, I have a felony. And this is problematic, right? So you have people who the system has agreed should be able to get this felony off their record in the future under certain conditions. But we're gonna suspend their ability to move forward while they're on probation. Amended the statutes 2 years ago, and then just went into effect about a year ago. Is that it's now considered a misdemeanor for most purposes until the judge designates it one way or the other. It's still considered a felony for courtroom purposes. So it's still a prior felony. If you screw up and commit another felony, you've got a felony prior. et cetera, but now you don't have to. Claim it as a felony on things like housing applications and job applications, things like that.
I have a question. So a lot of times we saw probation that, you know, people would complete probation successfully and then. The classic sober would be designated a misdemeanor, but then they would apply for jobs or apply for housing and it would still like show up as a felony. How, like, what is the process for them to kind of get that cleared up?
That's so, I often get questions from clients like, is this gonna show up on my record, right? Like my record is this gonna be, when is this gonna come off my record? And that's a really difficult question to answer because what is the record? And officially it's what's in the clerk's office. That's what the record is. But what they're referring to is background search, private background search companies like TransUnion and TLO and these other places that employers hire to run background checks. And there's really no oversight as to what data those companies can pull and how they report it. You know, they can't like recklessly give false information out, but they're just going on a database that Westlaw or Lexis has created that is just like sucking data up from all these various courts. And there's really no telling how that's going to get interpreted on this private company background check. So I'm sure that there are internal processes at these places. Like I just keep thinking of TransUnion and these others, but there are multiples. There's you know probably a process like with your credit score to request a update. But that's probably very laborious and time consuming and probably costs money. So I just advise clients to make sure that they keep good records themselves so that they get that order from the court designating it a misdemeanor. And you know, probably the best thing is to be upfront about these things. They can say to an employer, like, if you do run a background check, this might pop up, but just FYI. Or you can appeal to the employers like, that's inaccurate, you can prove it. But it's one of these things with I guess you're a big data that it's going to be really hard to have a legislative or rule-based fix to because we don't have control over that data once it leaves the clerk.
Okay, I have another question. Sorry. DUIs. So, can you explain in the best way what happens to someone's driver's license? Yes. When you get a DUI, pre-conviction, post-conviction.
Is bad. Yeah. Okay, I'll do my best. And yeah. You're pulled over by a law enforcement officer, suspect you of DUI. The officer can request that you do field sobriety tests and take a chemical test. So either a breath or withdrawal. I'm not sure about the FSTs, but if you refuse a chemical test, breath or blood, I'm not sure if the statute allows you to pick. I think you can elect one or the other. You just have to choose one. I don't know my head. Yeah. Anyway, if you refuse to do that, then you get an admin per se suspension, right? Yes. So this is so you haven't even been charged yet. But the officer has this sheet in his packet called the admin per se. That gets sent to MVD and it suspends your license right then and there. I think it's like 14 days. He gives you a piece of paper. He takes your license, gives you a piece of paper that's your license until that admin per se goes into effect. And then you have a suspended license. And then you have to apply to get a limited license of some sort or another. But then I think there's a suspension procedure even if you don't. Do the admin,
I think it's shorter, it's 30 instead of 9.
right? But the person can always request a hearing in front of an administrative judge, which didn't make it into that PowerPoint thankfully. Because the administrative courts are a whole.
Yeah, they're not.
Then the looks like somebody may be answering the question, but the long story short is that you can
Oh, Mary Ann. From PD.
You can get a valid license while your case is pending. Of some sort or another, but if you are convicted, then the court has to suspend the conviction to the MVD, and by statute it resuspends your license, even if you got it reinstated pending the outcome of your case. Holder are various regulations and rules about how you can, maintain it for a certain period of time or use it for certain purposes. That's about the best thing is to not get a DUI. Weigh that together. But
Yeah, I always deflected in time of day. I only knew the criminal side. I know that, yeah, it's and Sullivan was able to help us out with a bit. It's 30 days that it goes into effect. The officer picks the test. But yeah, you're suspended on multiple levels. And even if you get it back and then you're convicted, you can get suspended again.
So clients or defendants who are convicted of a DUI and have already gone through suspension of their license and it's already been given back to them upon a conviction, they should expect it to be suspended again.
So yeah, if it's suspended for admin per se, so for the arrest and they get it back and they're convicted, they should expect to see that suspended again.
Perfect. Thank you, Mary Ann. If someone refuses, then it's a year suspension. If someone blows over the legal limit, that's a 90-day suspension, with the first 30 days being an absolute suspension and the second 60 days, you're restricted from driving to work and school. Very common question I saw, just people not understanding what happened to their driver's license. So.
I did that. Totally understandable.
Awesome. Thank you, guys. Does anybody have any more questions?
So from the justice perspective, not from a behavioral health perspective, and you guys mentioned a number of things already. Is there anything else that the justice sees behavioral health could do that would benefit their clients in more practical ways? In any aspects that you see reoccurring, like, hey, case manager would have just done this, we made things so much easier. Is there anything that just pops up the top of your head? You did mention a number of things already, which is incredible.
I can't think of an instance where a case manager or behavioral health specialist like made my client's case harder or worse. I think it's good to think about your role as it pertains to the criminal justice system, is that it's hard to make it worse. You can really only make it better. But seriously, I think it takes some of the things, like sometimes, speaking for myself, you put a lot of stress on yourself for things that are just outside of your control, like I was saying before, I think from a criminal justice perspective, because the courts are so focused on proof, right? This is our proof beyond a reasonable doubt is like the animating concept of this whole system is what's the burden of proof? How can I prove it? How does it stick? Is to be very good documentarians, be very good communicators, and lawyers are the worst at this, myself included, which is we'll get a phone call from the person that we've been waiting for a call from, and then won't call them back right away, and then we'll call them back and not get a hold of them, get all pissed off, right? Man, I can never do things. But being available to communicate with the attorney is super helpful, because oftentimes we're under the gun. We have time constraints that we need to comply with that come up very suddenly. And if we're able to talk to a case manager and get relevant information quickly, that can really change the course of the case.
Can I add on to that? So I think a lot of times, like, going to court is a very scary process for people. And so a lot of times what we try to do with our program is like ask, when's your next court date? How are you getting there? Like, is it okay for us to go with you? I'm not sure how that works as far as like billing goes, but I think that also helps with rapport building with the clients to show them like, hey, we understand this is a very difficult process. It's scary. We have no idea what the outcome is gonna be. So let me sit with you in court, you know? So I think that has proven to be really helpful for our people.
It's really, that is really, I think compelling to the judge too, because they see a lot of people come in unconnected, basically, and just all alone, right? To see that they're already integrated in the community, at least subconsciously, makes a big difference, I think.
Thank you.
I don't think we have any more questions. I think we're good to call it. So I appreciate it. Thank you. Thank you both very much.
So for those of you online, thank you for joining. Thank you, Mr. Williams, Mr. Carver, for helping out, and our next workshop will be August 17th. It'll be regarding the admissions and to residential treatment. So if you haven't signed up for that, please do from a flyer that Michael sent out, and we will see you in a month. Have a great afternoon.